Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the State Court Administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The Clerk supervises the Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The Clerk supervises the Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the Court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the Court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The Court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The Clerk supervises the Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the Court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the Court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available.
Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good morning, please be seated. We are here on time set for our oral argument in file number 2025-0356, Eugene Berger versus Donna Berger. Sitting this morning are Justices Jared Tufte, Justice John Jensen, Justice Douglas Barr, and Justice Mark Fries, and I am Lisa Fair McEvers. Arguing this morning for the appellant is Jonathan Byers, and for the appellee, Kristen Binder. Binder, I'm sorry, I apologize, I should have remembered that. So Mr. Byers, as soon as you're ready, you may proceed.
May it please the court, counsel. My name is Jonathan Byers and I represented Donna Berger in the district court as I do now on this appeal. Prior to their divorce, the parties reached a property settlement stipulation involving their assets. And the two largest components of the assets of the parties were the marital home and Donna's state retirement plan. Because Donna had already been the one residing in the home, she kept the home pursuant to this agreement, but she agreed to surrender a portion of her state retirement. And the details of that were she was going to have paid from her retirement $1,275 for 5 years, and then after those 5 years she would pay from her retirement $1,375 for the next 15 years. So a total of 20 years of payments. This equalization plan was suggested by Eugene and then fine-tuned by the parties. After the divorce was final in 2022, I believe, the parties found out that ND PERS could not structure the payment by a quadro as the parties thought would happen or intended to happen. Problems with PERS being able to do a quadro is they couldn't change the amount midstream like we contemplated, nor would they be able to stop the deduction from Donna's retirement after 20 years. It would always have that deduction. So doing it by quadro did not meet what we intended to do. So to fix that, Donna signed two authorizations directly from PERS so that the payment amounts of $1,275 and $1,375 would be sent directly from PERS to Eugene's bank account. And that has been taking place for several years now. In 2024, Eugene filed a motion to modify the property distribution payment. And his counsel claimed at the hearing in October of 2024 that Donna's payments were coming from her bank account as opposed to PERS, which under the paragraph 30 of the settlement agreement would have required that they be irrevocable. At that hearing, I informed Judge Romanic that no, they were PERS direct authorizations and the payments were coming directly from North Dakota PERS, which under paragraph 28 of the settlement agreement did not require that they be irrevocable. So after the hearing in front of Judge Romanic, the parties filed post-hearing briefs and I submitted as exhibits to the briefs copies of those PERS authorizations showing that they weren't coming from her bank account, they were coming directly from PERS into Eugene's account. So Judge Romanic issued an order in December of 2024, and he correctly identified in the order that the only way he could grant Eugene's motion was to find Donna was not compliant with the terms of the court order. And in Record 79, that's his order from the hearing, Judge Romanic specifically stated, "Here the court simply cannot find that the defendant has failed to comply with the court's order distributing property and debts." So he denied Eugene's motion and found that Donna was in compliance with the court's order. Eugene's counsel then waited until Judge Romanic retired at the end of the year and then refiled the motion with a different title, which was a motion to compel compliance, which Judge Romanek had already, as I indicated, had already ruled on. There was an email exchange between the parties that was entered into the record. And in the email exchange, Eugene's counsel contacted me and said, "Are you still representing Donna?" I replied, "Well, that depends on what it's for, I guess." Her response was, "Same thing." To which I replied, "We just finished that and you lost." That in essence is issue preclusion, whether it's res judicata or collateral estoppel. Just having had this same issue before Judge Romanek, having had him decide that, precludes them from raising the issue again. But she filed the motion anyway. Judge Hammes was appointed to replace Judge Romanek. We resisted the motion and cited both of those issue preclusion defenses, res judicata and collateral estoppel. They had not appealed Judge Romanek's order. They did not file a motion to reconsider. They simply waited till a new judge was appointed and refiled the motion with a different title.
Mr. Byers, if we, hypothetically, if we were to agree with you that this issue or claim, depending on how you look at it, could not have been raised now, looking down the road, there was a situation where PERS discontinued payment to Mr. Berger's account. Would the next issue of contempt or another motion for failure to comply be also res judicata if the facts were different?
Chief Justice, I don't believe they would be. I don't believe that is res judicata. But I will say, although Eugene's counsel argues in her brief that this is a way to get around res judicata, is that the issue of the revocable nature of them wasn't discussed by Judge Romanek. That's not true. If you look at the transcript of the court hearing, he directly brings it up on, Eugene's counsel brings it up on page 7 of the transcript, that the fact that they're irrevocable. And then on page 9, I say to Judge Romanek, we can't change the fact that they have revocable status, but if Donna does something to revoke those, and right away Judge Romanek said, order to show cause. So he was cognizant of the fact that she could revoke them. If she did that, then we'd be back into court on an order to show cause.
So your argument, if I understand it, is that your client isn't compliant, I think it's paragraph 28, and the argument here is over paragraph 30, but paragraph 30 isn't triggered until paragraph 28 is violated.
That's correct, Chief Justice, and that's been a large part of the problem from the very beginning of this, is that we never get into paragraph 30 because it specifically says, if for any reason Eugene is unable to receive his payments from PERS, Donna will arrange a irrevocable payment from her bank account. We never get to that and have never gotten to that point because the payments are going directly from PERS, contrary to what they tried to argue at the hearing in front of Judge Romanek. So it's under paragraph 28, and it simply says, Donna will execute any documentation necessary to facilitate these payments directly from ND PERS to Eugene. She did that, and the payments have been occurring.
Mr. Byers, how does Judge Hammes' order address this? How does it make it irrevocable? Because you said under the quadro it can't stop in 20 years, and so I'm assuming she hasn't agreed that it goes on eternally.
Correct, Justice Barr. The whole problem with doing what Eugene's counsel suggested is that, first of all, the agreement didn't provide for that. But even if it did, that would totally change the equation of how they calculated the property distribution, because she'll get shafted for $17,000 for every year that she lives beyond age 77. So if she lives 78, 79, 80, every year, $17,000 she gets shafted that wasn't contemplated by the property settlement agreement.
Because it can't terminate.
It can't terminate. And that record of
Is that what Judge Hammes ordered, that a quadro be issued that's permanent in essence? Whether he said it, is that what resulted?
Justice Barr, I'm not even clear on what he was ordering, because he simply said, I'm granting the motion and I'm ordering that I'm compelling compliance, but then he didn't find her non-compliant to the effect that he was going to wait to see what the parties did. I think he was expecting we would just read his sentiments and agree that the payment should be modified, and we did not agree that the payment should be modified. That's why I appealed the case.
And does the modification of the amount, so it's equal for 20 years, is that a financial harm beyond, if it goes beyond 20 years, because of present day value or anything like that?
Justice Barr, I didn't really even calculate that. I guess because it's so far outside of what the parties were contemplating. And it would, like I said, doing something like that when we have a clear record that was entered into the record from PERS saying we can't change this after 20 years, she'll always be losing that $1,375. It was so far out of the realm of what we contemplated that I didn't even do any other calculation.
What prohibits your client from reapproaching the district court at a later time if it's going to start causing harm? Because Judge Hammes relied in part on the statute that allows him to take a look at a judgment and the equitable nature of that to modify it at any time, and found these as very distinct proceedings. A motion to modify the judgment versus a motion to change the judgment.
Justice Freeze, I worried a little bit, and after he issued his order, I did step back and think about what are our options here. But I was worried if I did that, I was going to be in the same boat of looking at issue preclusion if I didn't do something with Judge Hammes's order, that if I came back later and tried to do something, I was going to be in the same boat of some kind of issue preclusion where I should have brought it up at the time and I didn't. And it really is clear. I think Justice Hammes was wrong in just glossing over the issues of res judicata, and the rationale he does for that I don't even understand, or I don't think is correct. But even factually, he didn't take into account how much this was going to change the property settlement agreement. He just assumed that we would somehow allow come to some different number that was going to be withdrawn from her PERS account, and we would just be satisfied with that. I asked him at the end of the hearing, even though he had kind of just glossed over it and went right into the merits, I asked him to reconsider his decision that res judicata and collateral estoppel didn't apply, because I was kind of flabbergasted or whatever that I hate the phrase no-brainer, but it seemed that clear to me that this was the same issue. And counsel recognized it was the same issue by saying to me, what is this about? Same thing. So my client has been required through this process to spend a bunch of money that she didn't have. So I asked the district court for attorney's fees, and I'm asking the Supreme Court now to apply and to remand this back to the district court for assessment of attorney's fees, that the decision on res judicata and collateral estoppel was wrong, and to overturn that, and to also direct that the district court grant Donna attorney's fees, both for what had been incurred prior to Justice Hammond's hearings and even through this appeal. So that's my request to the Supreme Court.
Mr. Byers, remind me what your requests for attorney's fees below were based upon. Were they based upon need versus ability to pay, or some statutory authority? I forget what your request was below.
I believe it was primarily on need because, as I indicated, with the reason well, there was even a change in the amounts of the PERS payments was because Donna could barely afford the $1,275. And the idea was that after 5 years, she'd be eligible for Social Security and therefore could manage to afford that other $100 per month that she was going to have to pay. So she had a definite need, and I was demonstrating to the court that having to respond to this motion to modify judgment rephrased as a motion to compel compliance was something, because of issue preclusion, we shouldn't have had to do. And because of Donna's need, I asked the court for my attorney's fees up through April of last year had been $2,600. Then we had to have the court hearing in front of Judge Hammes, and now we've had this additional year of the appeal, which is a substantial expense for somebody that was worried about $100 per month. Thank you.
Ms. Binder, when you're ready.
Chief Justice, Justices of the Supreme Court, my name is Kristen Binder. I am counsel for the appellee, Eugene Berger, who is here with me today. I do want to clarify a few points right away. So the quadro that was required under paragraphs 28 and 29 of the judgment was actually filed with the court in March of 2023. I think that reiterates the fact that a quadro was required, contemplated by the parties, and that is how Eugene anticipated to receive his payments, not through a direct deposit form from ND PERS to Gene. It was always in the context of a quadro. So the 20-year term certain that the parties agreed to can in fact be effectuated by ND PERS. The problem is the two-tier payment structure that ND PERS cannot comply with. What Donna's counsel is arguing now and at the last hearing is that after judgment was entered, we became aware that her pension payment would be permanently reduced regardless of when the term ends. So Gene's payments will continue for the 20 years. The impact on Donna's payment after the 20 years was discovered after judgment was entered. However, it doesn't change the fact that the quadro was agreed to in paragraphs 28 and 29. A domestic relations order was in fact filed and signed by the district court. And it doesn't negate the fact that the parties agreed to a $324,000 property equalization payment via a quadro. The main concern has been from the beginning that these payments be secured. They need to be secured. It's over a 20-year period. If we were agreeable to some direct deposit form, whether it be through Donna's bank account or ND PERS or any other avenue, they are revocable. She can revoke it at any time. Now, that's not the main concern. We don't anticipate that she's going to stop payments. What the main concern here is, if Donna predeceases Gene, those payments cease. There is no avenue for him to obtain the full property equalization payment at that point.
When you say ND PERS can do a 20-year term,
20-year term certain.
You're saying that means his payments stop, but it doesn't term for her, so her benefits don't go up.
That's correct, but
So that's just too bad, so sad from your perspective?
It was discovered after judgment was entered. If that was to be taken into consideration, if they wanted that to be adjusted, a motion to modify would have been the appropriate avenue to get that consideration. And going a little off the record with all of this, I mean, we've been in extensive negotiations for years. This judgment was entered December of 2022. We have exhausted all ideas to try to resolve this without litigation. The problem is there is no security for these payments, and Gene was left with no
Then why
option.
not appeal Judge Romanik's order?
My client elected to accept Judge Romanik's order at the time. His ruling in our eyes was a motion to modify was not appropriate. However, that doesn't negate the ongoing obligations under the judgment.
Well, why couldn't the second motion have been brought as part of the first motion? Why couldn't the
Because
same, if it is different, if it is something different, why couldn't it have been brought at the same time if this has been the ongoing problem for years?
Because ultimately, we were trying to correct the underlying issue with the two-tier payment structure and not increase litigation. We wanted this resolved. We wanted the court to resolve the underlying issue of the payment structure so everybody could move forward and that we wouldn't have to be in this
Although labeled
situation.
differently, both motions make the same arguments from when I read them, non-compliance, and both request the same relief.
So I would dispute that. The first motion is a motion to modify. Again,
Based upon non-compliance.
based in part on noncompliance because of Donna's refusal to execute a stipulation to amend. Now, the big issue we have here too with this first motion, we weren't able to litigate it in any capacity. We weren't allowed to present testimony or evidence. In fact, Judge Romanik at the beginning of the hearing explicitly stated, this is a closed case. I'm not reopening this. He ultimately allowed oral argument, but we weren't allowed to have ND Pers come testify who were there at the time. We weren't allowed to have the parties testify or vet these issues out further.
But wasn't that because he said as a matter of law, there was no non-compliance? And then your second motion is saying, we disagree with that conclusion, there is non-compliance.
So in the first, I guess the first hearing, it wasn't clear at the time of the hearing that what his analysis was and why he was refusing to allow a hearing on the issues. Again,
Wasn't that his ruling? There's
his ruling
no non-compliance with paragraph 28, because it's not,
his ruling specifically states that Donna is making payments. That is it. There is no additional analysis as to the second part of paragraph 30. So paragraphs 28 and 29 require a direct a payment to Jean through ND Pers via a quadro. Paragraphs 28 and 29 do that. Paragraph 30 then states if payments are not able to be made to ND Pers, at that point, the two obligations of paragraph 30 are implemented.
Based on your arguments, I still don't understand why an appeal of Judge Romanik's order, if you're saying the court abused its discretion by not allowing witnesses to testify or not, I mean, there are issues that could have been raised on an appeal that
Hindsight.
were not raised, yeah.
Hindsight, right, 2020 always, and the fact of the matter remains, these cases are expensive. Litigating matters are expensive. And we were hopeful that if we did let it sit for a minute and try to reapproach it, that maybe we could make some headway, because the fact remained that Judge Romanik only indicated payments were being made, not whether or not they were irrevocable, and not whether a stipulation to amend was required. Those are two separate obligations in paragraph 30. So the irrevocable payments that are required, that's separate from the stipulation to amend. We put that in there specifically because we could not get a hold of ND Pers prior to the stipulation being signed. So we
When you
want.
refer to, I don't think I appreciated this fully when I read the briefs. When you're referring to irrevocable payments, you're not worried about Donna choosing not to make the payments.
No.
Because a court order ordering her on penalty of contempt to make those payments functionally makes them irrevocable in a practical sense. You're worried about her predeceasing and the payment stopping because the entitlement to payment stops.
Correct.
So irrevocable in the sense of a binding obligation on PERS for survivor benefits.
Yeah, and the fact remains, I mean, if irrevocable payments would have been established, or there would be some safeguard to the current payment structure, some sort of safeguard that Jean is going to be paid out the full property equalization payment if Donna predeceases Jean, we wouldn't be here. We wouldn't be here. The problem is the payments are revocable. They can stop at any time, or if she predeceases, they stop completely, and there's no recourse. And I think Judge Hammes, he was aware of that, and the Donna's counsel had indicated at that point that Jean could make a claim against her estate. Well, the parties agreed contractually to Donna paying $324,000 over a 20-year term certain via a quadro. That is not possible with the two-tier payment structure. When we were unable to get a hold of ND PERS, we specifically included paragraph 30 to address that contingency, to include some plan to allow the security of these payments. Now, if Jean would have been fine with a direct payment from Donna, we wouldn't have paragraphs 28 through 30 at all. It would simply say Donna pays Jean X amount of dollars for 20 years. That's not the case. We wanted security from the beginning. And she's arguing, yeah, the payments are being issued. Donna had to sign a direct deposit form essentially with ND PERS indicating X amount of dollars goes into her account, X amount of dollars goes into Jean's account. Yep, they're coming from ND PERS technically, but not under a quadro. And I think that's what's been missing in this from, the Judge Ramonic's order, is that wasn't understood. The payments from ND PERS are to be paid via a quadro. The DRO was entered, signed off on, it wasn't qualified because ND PERS couldn't do it. At that point, paragraph 30 is then triggered, and there are two distinct obligations there. So Judge Ramonic did state that direct payments were being made. There are no findings at all in his order regarding the stipulation to amend requirement.
And there wasn't evidence taken, you said, on which the findings could have been made. Is that fair?
Correct. So the matter initially was not fully litigated. It was not fully litigated. And when I had reached out to Attorney Byers after that initial order, and I did say, it's the same thing because of the continued non-compliance. But there are separate requirements within that judgment, and res judicata and collateral estoppel should not shield a party from ongoing non-compliance with the judgment. With this matter, I think it's also clear from Judge Ramonic's order that he was relying on paragraph 30 when he was doing his analysis. He indicated that payments were being made, again, but if you're relying on paragraph 30, then you have to look at whether or not those payments were irrevocable. In addition, no analysis whatsoever was done on that. In addition to the stipulation to amend, again, two distinct requirements in this judgment if the quadro cannot be effectuated.
So I was just looking at the transcript from the first hearing before Judge Ramonic, and your argument about Ms. Berger predeceasing your client was made there. So the issue was raised before Judge Ramonic.
I think it's an issue, but it's not the main issue that the motion was brought on. The motion was brought on the issue of we were asking the court to amend the judgment to fix the underlying issue of the two-tiered payment structure. That's been the goal, from the beginning. The fact remains, there's been no findings, no litigation at all on the second portion of paragraph 30 whatsoever. And that issue, even if the court finds that the compliance finding by Ramonic, as far as Donna making simply direct payments, is sufficient, that doesn't shield her from ongoing compliance from the remainder of the terms of the judgment. There are two distinct obligations in paragraph 30. And again, going back to paragraphs 28 and 29, if you read those paragraphs as a whole, what you're looking at is a requirement for a quadro. Paragraph 30 then states, if payments from ND PERS cannot be received, which, reading the preceding two paragraphs, it's clear that it has to be through a quadro, then we look at the irrevocable payments and the stipulation to amend judgment, two separate things. So again, the reality is if irrevocable payments were being made or there was some safeguard currently, we wouldn't be here.
How do you read Judge Hamas's order? Both parties must comply. That's really all he says.
Yep, with paragraph 30. Yep, with paragraph 30. So
It says with the current judgment.
yes. So I think, and my reading of it as a whole, to me, my understanding is the parties need to comply with paragraph 30. Judge Hamas is aware the quadro or the domestic relations order can't be effectuated as is, which then triggers that paragraph 30.
And how does, if the concern is with Ms. Berger predeceasing, how does that address the issue unless there's over $300,000 sitting in her bank account?
So it addresses the issue because the parties are then required, or Donna is required, to either set up an irrevocable payment to Jean, or I should say and, it's not an or paragraph, and the parties need to work towards a stipulation to amend the judgment to effectuate paragraphs 28 and 29. What that would mean is changing the payment to one set payment over 20 years. That would be the effect, and it would correct it. There's no wording within paragraphs 28 and 30 that make it seem as though direct revocable payments are acceptable. Again, if it was, that language would not be included at all. So ultimately, we are asking for the court to affirm the district court's order. Should this court reverse the decision of the lower court, it would potentially bar Jean from enforcing any judgment provision that was the subject of a prior motion, regardless of continued noncompliance. Again, the more significant concern by far is if Donna predeceases Jean, the payments will immediately cease. And this is by its very definition unjust. The parties are well into their 60s with payments being made over a 20-year period. And as it stands, Donna's noncompliance of the current judgment puts at risk the property equalization payment that the parties explicitly agreed to. This court has said that the doctrines of res judicata and collateral estoppel should not be applied so rigidly as to defeat the ends of justice. Res judicata and collateral estoppel are doctrines designed to promote the finality of a judgment and not to shield a party from continued noncompliance. So we would respectfully ask that this court affirm the lower court's decision. Thank you.
Thank you, Ms. Binder. Mr. Byers, you have 10 minutes reserved.
I don't think I'll take all 10, but I do want to say, I should have kept track of how many times counsel said should not shield the parties from ongoing noncompliance. Well, the whole issue is Judge Romanek determined that Donna was compliant. So counsel might have it in her head that there's this continued noncompliance. That's an issue that the courts, through these doctrines of res judicata and collateral estoppel, should never get to, because Judge Romanek determined that she was compliant.
What was the factual basis for that determination? Did the court have evidence on which to make that determination?
Well, at the hearing, counsel tried to argue that Donna was making the payments from her bank account to Eugene's bank account, which would not be compliant with 28 and 29. But that's not the case. I said right away, no, Judge, their North Dakota PERS authorizations. It goes directly from PERS, never gets to Donna. It's going into Jean's bank account. That's what he determined makes it compliant.
So the court
And-
had exhibits in its file that it can make that determination?
I had him at the hearing, but the judge preferred that I file them into the record after the hearing. So with the post-hearing brief, I attached them as exhibits so that before he issued his order, he could see that they were PERS authorizations.
Were they in the evidentiary record, or were they just filed? We've had trouble with that. Some documents get filed but are never admitted.
He specifically directed that they be filed, so I said I had him at the hearing, but he directed that they be filed, so I'm.
Did you ask that they be received as evidence? And he and opposing counsel have the chance to object?
I don't recall.
This wasn't an evidentiary hearing, as I understand it.
That's
It was
correct,
argument.
Justice Barr. He determined that we weren't going to have any witnesses because he thought it was a matter of law as to whether Donna was non-compliant or compliant. When I brought up the fact that they were PERS authorizations, opposing counsel asked to see them at the hearing, and then we both talked about them in front of Judge Romanek, and then he directed that I file those into the record after the hearing. Again, there's been repeated times where counsel has indicated that this is a problem with paragraph 30. I don't think we ever get to paragraph 30. These are the clear language that starts out the paragraph. If for any reason Eugene is unable to receive payments directly from PERS, and then it goes on with the rest of the paragraph. That's not the case. He's receiving his payments directly from PERS. So the thing that triggers paragraph 30, it does not occur.
But is he? They're going to your client's bank account first.
No, they are not. Counsel tried to argue that, Justice Freeze, that they were going from her bank account to Eugene's. They're not. They're going directly from PERS. She never touches it, nor does her bank ever touch it. They're going directly into Eugene's bank account from PERS, which takes paragraph 30 out of the picture.
And who has authorization? Only PERS can change that? Can your client change it?
My client can change it, but that was brought up to Judge Romanek, Justice Freeze. That fact that they were revocable, she can, but that word revocable only appears in paragraph 30. So if you never get to paragraph 30, that's the only place where there's any discussion about the revocable nature is in paragraph 30 relating to her bank account, which we're not using her bank account to make the payment. There is no revocable word in paragraph 28 or 29.
And if your client were to convert her retirement account into an IRA, the enforcement mechanism for the opposing side would have to be a petition to enforce it.
Right, and that was brought up, Justice Freeze, that was brought up at the hearing in front of Judge Romanek that she could revoke them. But then Judge Romanek, without even me prompting him, said order to show cause if she does that. It was also brought up by counsel that fact that that Donna may predecease Jean, and she brought it up, and Judge Romanek addressed that both in his order and at the hearing. So again, those are issues that were all dealt with, and not appealed by Eugene. So this is a clear case of res judicata. It's cost my client a bunch of money, even though she's making having PERS make the payments as indicated. And Eugene has the recourse of filing a claim against her estate if she does pass away, which was considered by Justice Romanek, so nothing's changed. They're trying to relitigate the same issue. Thank you.
Thank you, Mr. Byers and Ms. Binder, for your arguments this morning. This case will be taken under advisement, as all cases are, and this court is adjourned until 1:30 p.m. on Wednesday, April 15th.